Hi, this is Mimi Coffee, and I'm interviewing Mike Mosher. Mike Mosher, I will let him tell you a little bit about himself, but he is both a civil lawyer and a criminal defense lawyer. And he has something very important to say about junk science in criminal courts. Mike, please introduce yourself.
I'm Mike Mosher from Paris, Texas. I started out trying cases against drug companies. In 1992, I won the first case to go to trial against Upjohn over the drug Halcyon. In 1993 came Daubert, and the world of science and junk science and what is science changed in the civil courts. In the civil courts, what you essentially are forced to do is confirm that your science is valid. And typically that means that you've established your proposition to what's known as a 95% confidence level. In other words, is the probability that what you're arguing is, for instance, causation in a drug case, have you excluded the possibility of chance to a 95% confidence factor? In other words, there's less than 5% chance. It could occur by probability that it could occur by chance. And that's how it works in civil courts. And civil courts keep out bad evidence and sometimes good evidence. It's totally different in criminal courts. Let me just give you an example. Recently, I had a case, an involuntary manslaughter case, and the medical examiner from the Dallas County Medical Examiner's Office was testifying that my client had caused the death, in essence, of a 2-year-old child by negligently providing morphine. There was no evidence that he had actually done it, but there was that a young 2-year-old ended up in the hospital with respiratory problems, and they took her, not her blood, they took her urine and found morphine and codeine. So they never had a blood level. A number of other things I'm confident actually caused her death, but the medical examiner claimed that it was morphine. As a matter of fact, morphine and codeine in your blood is not evidence that you had morphine. It's only evidence that you had codeine, because codeine breaks down into morphine, but not the reverse. So if you have codeine and morphine, you only have proof of codeine. Cross-examined him on this in a Daubert hearing, moved to exclude his testimony after you've established, in essence, that it's just totally junk science. The judge turns to him and says, "Have you been admitted and allowed to testify in other courts?" "Yes, Your Honor." "Well, in that case, I'm overruling your motion to your Daubert hearing. He can testify." And that's the kind of thing that comes in criminal courts all the time. All too often, the judge looks at the expert and says, "Have you been allowed to testify before?" And if he's been allowed to testify before, he's allowed to testify to whatever he wants to say. The state has the ability to put on virtually anybody they want in a criminal case, in the kind of evidence that would never come in a civil case. And it really is outrageous.
Thank you, Mike.